Our next speaker is Gerard Holmes, QC. Gerard has been a lawyer for many years, having graduated way back in 1978 with a Law and Eco degree. And he practiced as a solicitor until 1994 when he decided to become a barrister. Now, at the bar, he's been involved in many high-profile financial and parenting cases. But while he might be good at the high-octane court battles, he doesn't think that they are necessarily the best way to resolve a dispute. And Gerard is a passionate advocate of mediation and arbitration, and I think it'll be very interesting to get his comments about this proposal for a tribunal. Would you please welcome Gerard Holmes, QC?
Well, good evening, ladies and gentlemen, and thank you for the elevation, actually, Damien. I'm not actually a QC, but one day I might get there. But so it's just plain Gerry Holmes. Thank you very much for your delivery, Chief Justice. I agree with you that it's good at last to see that the government are recognising that there are problems in relation to the system. And that through this review over the next 18 months or so, that some good will come of it. It's in relation to the tribunal. I've got some real concerns, though, in that, as we all know, as family law practitioners, most of our cases resolve, and that's because most of us are able to tell our clients what the law is, and most of our clients do accept what the law is, and then we don't have to go to court. There's a settlement, or if something has been issued, we can resolve the case without having to go all the way to a trial and judgment. But as our society has become more and more complex and more and more acceptable of various forms of behaviour, and has become more and more acceptable of the concerns that a lot of us don't experience, that is, problems in relation to racism, problems in relation to revenge, if one party to the marriage or the relationship hasn't accepted the fact that relationship has broken down, it's very hard to convince our clients who may be revengeful that it's silly to run this case, because you won't get the result that you want if it's just pure emotion that's driving the instructions. There are also problems, of course, as we know, that certain clients, certain people have. Problems with drugs, problems with alcohol, problems with attitudes to women. We still see a lot of chauvinism, and so that's often the reason why a matter won't resolve. I'm going to not allow this woman to get the sort of result that she should get because she's a woman. These attitudes still remain in our society. And so is this tribunal going to be able to deal with that? I doubt it very much. To be limited to 20 minutes of submissions, no cross-examination, how on earth are these tribunal members going to be able to make a decision as to who's telling the truth? What I think the government really should be doing is not another political dress-up or a political dressage. It's probably, as Damien said, I'm a firm believer in mediation. But I'm also a firm believer in arbitration. Arbitration is a concept that has been around for a while, but it really hasn't got much legs, or many legs, for a variety of reasons. And probably one of the reasons is that, like when mediation had its genesis back in the 1980s and 1990s, it did take a while for the concept to be accepted by us as practitioners, because by and large we are a conservative lot. We don't really like to go out of our comfort zone. But one by one, as these mediations started to occur, we realised this isn't a bad way for our clients to understand, with the help of an independent mediator, not on either party's side, but able to bring out of both parties what really is their concern and reality test their concerns, that eventually the parties will get a resolution that they own, a great form of dispute resolution. But there often still is an aspect of the dispute that hasn't been able to be mediated. So that's when an arbitrator can come in and make a decision in relation to the issue that may in fact be holding up the mediation. For example, the valuation of a business, or whether an aspect as to whether a pre-marriage contribution should be relevant or not. But what is lacking at the moment in relation to our Family Law Act is that arbitrators can't deal with parenting issues. So if arbitrators are able to deal, if the legislation could be changed in that regard, it would enable arbitrators and possibly arbitrators that are paid for by legal aid, as does happen in Queensland legal aid. That would be a great way to actually assist in reducing the backlog of cases in relation to parenting issues. So it's the practicalities of the tribunal I've got real concerns with as to whether it's going to work or not. So perhaps I might finish there. Thank you.
Yeah,